Everybody, thank you for your patience and thank you for joining, and welcome to our webinar on GDPR and the impact of GDPR on your business and how to prepare your workforce. I'm joined today by my colleague Piers Clayden from Clayden Law, and the two of us will be talking to you today about GDPR. There is an opportunity for you to ask questions in the control panel of the web controller webinar software. You can see a section there about questions, so everybody's muted at the moment to avoid chaos, but if you would like to ask any questions, if you could type the questions in, and at the end of the session, at the end of the webinar, we'll address the questions and answer them for you. So as I mentioned, there's myself, I'm from New Learning, and my colleague Piers from Clayden Law will be presenting today's session. We'll kick off in a moment with Piers, who's just going to give you a background of the GDPR, why it's a game changer, and so the key implications to small businesses of GDPR. And then Piers is going to pass over to myself, and we're going to talk a little bit more about some training resource that Me Learning have created to help you with your GDPR, to get a better understanding of the GDPR and to help you educate yourselves and your workforce. So to no further ado, I'm going to hand over to my colleague Piers. Are you there, Piers?
I am, Nick. Thank you very much. Can you hear me okay?
I can hear you fine. I shall mute my microphone and hand over to you. Thank you.
Great stuff. Okay, good afternoon, everyone. Thanks so much for joining this session specifically on GDPR for small businesses. It's great to have you here. I am going to talk to you briefly around the legal background to this new regulation, and then talk about some practical implications for you as a small business. So hopefully you'll be able to draw some practical tips from the session. Little bit of background on the GDPR. It's a European piece of legislation which was published in February 2016. It's coming into force in May 2018. So we've had just over 2 years to get ready for it. We would have had 2 years to get ready for it by May next year. As a European piece of legislation, you may be wondering why we need to bother in light of what's happening on the European stage and Brexit. The UK government have, and did very quickly, put their mark in the sand on this and say that notwithstanding Brexit, GDPR is here to stay. Not only that, they're going to extend it into areas of life that it wasn't previously touching. And they've done that by way of a new data protection bill, which is currently going through Parliament, which will basically mean that GDPR will very much be in force from May next year, and will be here to stay when we leave. So many businesses of all sizes depend on personal data, whether it's personal data of their employees or whether it's marketing data, prospect data, and that sort of thing. And so it's a really important piece of legislation from a compliance point of view for many businesses. And why it's so important now, more than ever before, given this new piece of legislation, which by the way is probably the sort of most significant data protection legislation that we've had for the last 20 years. It has introduced some really quite severe penalties for non-compliance, perhaps up to 4% of global annual turnover, or 20 million euros, whichever is the greater. But perhaps even more important than that is the increased liability picture for non-compliance over and above those sorts of fines. It is a much more complicated one, because the GDPR will give individuals greater rights over the use of their personal data, and greater ability, an easier ability, if you like, to bring actions for claims for damages if their rights are infringed. And also, because the regulation for the first time brings into play a mandatory breach notification procedure, whereby you have to tell the regulator if you've suffered a breach under many circumstances. That will obviously mean publicity for companies who have suffered a security breach, and therefore potentially come under scrutiny of the ICO for non-compliance with data protection legislation. So the good news is that the GDPR builds on the current data protection regime. Many of the concepts and principles remain in place and will be, as you would understand it, currently. So we have the concept of data controller and data processor and personal data. They are all by and large the same. To be fair, personal data has that definition has been widened to include online identifiers and IP addresses, and it's obviously to reflect the advance in technology since the last piece of legislation. But by and large, I think most lawyers understood those sorts of things to be personal data anyway. Certainly the courts did, and so in that respect, there hasn't been a huge amount of change in the terminology in those areas. However, what the GDP has done is introduce some fairly new concepts around the way in which you look after information and the way in which you use it and the uses to which you can put it. And I'll come on to those in a moment. But in terms of compliance, often, especially perhaps at the SME level of the picture, it may be seen to be an IT issue, but it really isn't an IT issue. IT may be a key to achieving compliance, but it certainly isn't. It certainly doesn't begin, and certainly won't end in the IT department's door. There needs to be top-down buy-in to change, cross-organisational change here, because it really does touch on many different facets of business: sales, marketing, HR, vendor, supply chain, that sort of thing. Nick, if we go on to the next slide, please. Thanks so much. So the first implication that I really wanted to bring to your attention was this is one of the new things that the GDPR has brought in, and this is the principle of accountability. And in short, this is could be summarised as saying this isn't just complying with the law, but it is being seen to comply. So organisations are going to have in place policies and procedures which will enable them, if they are ever audited by the regulator, to show the regulator how they have been complying with the GDPR. It's all about demonstrability, and this is perhaps where the greatest bureaucratic burden will fall on smaller businesses. So what are we talking about here? Well, for example, one of the key areas is around knowing exactly what your personal data landscape looks like, and how are you going to do that? Well, internal records are an important part of the of this. There are exemptions for organisations which have less than 250 employees, but actually, when you drill down into when those exceptions apply, given that they don't apply where you are monitoring or handling sensitive personal data, in our view, and from a demonstrability point of view, I don't think that exception is going to be an awful lot of use to many organisations. So having internal records about how you process data, where you process data, where the data has come from, who you've given it to, the who, what, when, how, and where of your personal data landscape is key. Some organisations will be required to have a data protection officer. This is a high-level appointment, someone who is effectively a guardian, a privacy guardian, and should be able to kind of report into the board and hold their own at board level, and generally hold the feet to the fire of the organisation to make sure that they comply with the privacy regulations. And that it's mandatory in the scenarios where you are doing large-scale personal data monitoring or handling a lot of sensitive personal data. It's also mandatory for public authorities, but also less an issue for this audience. The GDPR also is more stringent than the Data Protection Act in relation to information security measures, and lays down some requirements in that area. And then also the GDPR is very keen that organisations take privacy to their hearts, if you like, and very much within the processes of the organisation have privacy not just as an add-on, as an afterthought, but very much front and centre in everything they do. And they require this to be done through various measures, but they call it privacy by design or privacy by default. So making sure that privacy is included as a concept when you are looking at new products and services, making sure that privacy is always the default option, data minimization is key, and when you're undertaking potentially risky new activities, the GDPR will require you to carry out what's called a data protection impact assessment to assess those risks and think about them, think about mitigation measures, and indeed think about whether you should be doing it at all. And in terms of what to do from a practical point of view, clearly you need to know where you are at the moment to know how far you've got to go to become compliant. So a data protection audit would be a good start there. Make sure your record keeping is up to date, insofar as it is recording all your activities and any consents that you may have. Think about appointing a data protection officer. Update your internal policies and your privacy policies to make sure they are compliant, and indeed make sure your staff are aware of their obligations and indeed the company's obligations under the Data Protection Act. And this is where the me-learning GDPR modules really come into play as a great way of getting your staff up to speed quickly and efficiently with the new regime. Companies that have got existing code certifications like ISO 27001 will be a long way down the line in relation to this these sort of information governance requirements. That's not to say that that will be the be-all and end-all. GDPR compliance goes beyond just ISO certification, but as I say, it is a great way of showing to anyone who might be auditing you that you are taking your information governance obligations seriously. So Nick, perhaps we can go on to the next slide now, thanks. Now, all data processing under the existing Data Protection Act and indeed the GDPR has to be lawful, and in order for it to be lawful, it has to be done on one of 6 grounds, and one of those grounds is consent, i.e., the processing has been consented to by the individual concerned, and many organisations have relied historically on a very relaxed opt-out basis in relation to the whole consent area. That, unfortunately, under GDPR will become a lot more difficult to get over that hurdle, because consent now has to be freely given, has to be very specific to the processing that is being consented to. So one-line consent statements for a broad range of activities will no longer cut the mustard. It must be informed, you must be very transparent with individuals about how you're going to use their data and the consent that consent's attached to it, and it must be unambiguous. So in other words, silence pre-tick boxes and inactivity is not enough to show consent. There needs to be a clear affirmative action. And perhaps as important is that an individual should be entitled to withdraw that consent as easy as they gave it. So Nick, if we just go on to the next slide, please. Because this deals with individuals' privacy rights, this is an area that attracts a high level of fines for non-compliance. So in terms of what to do next, if your consents currently are best practice and fulfill the GDPR requirements, the good news is that you don't need to go and get them again. However, most consents won't fulfill those requirements, and therefore, if you do need to rely on consent to be able to carry on processing that particular data, you will, I'm afraid, need to go out and get that consent again. And clearly that does raise the question about people not positively opting in, but unfortunately it is a quandary which is facing many businesses about compliance versus commercial imperatives. You should be able to obviously keep records and demonstrate exactly how and when that consent was given. You need to have processes in place to deal with how you're going to carry on your activities if that consent is withdrawn. And also, of course, think about other legal grounds for processing and performance of a contract. So, for example, an individual has given you their personal details for you to send them some goods or provide some service. Of course, that is necessary for performance of that contract. That's an entirely valid means for processing and doesn't need consent. Nick, I think we'll move on now, thanks. The next area that's new, for those of you who are either data processors, so in other words, you process data for your customers, or you are a customer and you have outsourced some functions, the game has changed a little bit in this area as well, insofar as processors are now subject to the GDPR themselves. Previously, that wasn't the case, and data processors used to be able to hide behind the data controller, who would be who had the full burden of the act, but not so anymore. Despite that, data controllers, because they are responsible for their data processors, they need to effectively get very strong assurances from data processors that those data processors won't put them, the customer, the controller, in breach of GDPR. So you can expect, if you're a data processor, a much more intrusive, if you like, vetting procedure for in respect of your customers, making sure that you can comply with GDPR. And if you're a controller who does outsource, obviously you need to put in place procedures which will enable you to demonstrate that you have not just ticked a few boxes and signed the contract, but you've actually done your due diligence on your data processors. The GDPR has some specific requirements about what your written agreement with the processor must look like. And in terms of your action points, just sort of touching on what I've already said, really, look at your current data processing agreements that you have with your outsourced organisation, vendors. Make sure that they are amended and brought up to GDPR compliant standard. Update your standard procurement terms if that's appropriate. Ensure that they have the necessary obligations in them. Carry out a due diligence exercise on your existing data processors to make sure that they can all sign up to the GDPR requirements. The obligation there is to make sure that processors have given sufficient guarantees that they can comply with GDPR. Make sure that the agreements are very clear about what processors can and can't do with your personal data. And given the increased liability picture with GDPR, make sure that the agreement contains appropriate indemnities and limitations of liabilities so that allocation of risk is properly covered. Thanks, Nick. Next one. So I mentioned this at the top of the webinar about this new breach notification, which kicks in whenever there's been a security breach which leads to the accidental or unlawful destruction, loss, or disclosure of or access to personal data. And it doesn't need to be a hack. This could just as easily be that awful sinking feeling when you realise that you've replied to all on a global email, a business email. It really is as low level as that. And the obligation to report is a 72 hours obligation, so that's not business hours, that is any hour of 60 minutes, and will kick in unless there is unlikely to be a risk to individuals. And that area of risk and ascertaining risk is actually a complicated picture, and I suspect there are going to be a few businesses who want to necessarily take the risk of not reporting and risk of fines. There's also where there's a high risk to individuals to notify those individuals themselves that their personal data has perhaps been accessed without permission, and what can help you there is having in place strong information security measures, such that you have got encryption there, or remote wiping of devices that have been left on trains. That sort of thing is a great way of mitigating those risks, and if you can show that, and if you can do that, there's certainly a good chance that you'll be able to not have to notify individuals, but perhaps in a very strong information security setup, you may even be able to show that you don't need to notify the regulators. So there are great mitigation strategies out there, should you choose to use them. The failure here to report attracts a lower level of fines, but obviously a report will bring you into the gaze of the ICO, who may in turn then think about doing an audit, and indeed if they find anything else that hasn't been happening, that should have been happening, you may be liable for a fine for that underlying breach as well. Your data processors must inform you as a data controller if there's been a security breach. They don't have to inform the regulator. And the next slide, please, Nick. Thank you. So in terms of action points on this one, good idea, I think, to certainly for those organisations who do handle a lot of personal data and maybe have a lot of employee data, to think about having a data breach response plan. Make sure everyone knows what their roles and responsibilities are if the worst was ever to happen. So carry out some sort of trials or war games, if you like. Think about upping your information security measures, such that breaches you can actually tell quite quickly what's been breached, and are you able to manage it remotely. Are your records fit for purpose? So could you quickly work out who to tell if you have to do that? And then finally, think seriously about encryption as a means of mitigating that particular risk. Thanks, Nick. I think we're on to our final implication now. Thank you. Again, I touched on this at the beginning, but individuals under the GDPR now have much greater rights around their personal data, and one of the ones which has had some attention is this so-called right to be forgotten. An individual can require you as a controller to erase their details if it's no longer needed, or they object to it, or it's otherwise unlawful. There are exemptions for compliance. For example, you need to keep the information for legal reasons, and we await further guidance on how that's exactly going to work. Individuals can now, their subject access request rights are actually broadly the same as they currently are under the Data Protection Act, although you no longer have ability to charge for those requests. I think at the moment you can charge up to £10 for a subject access request. I mean, that unfortunately has gone now, unless it's an excessive amount of requests, and the timing for that has changed slightly from to 1 month. I think it was 28 days previously. Automated decision making. So this is profiling effectively where there is no human intervention. Individuals have a right to appeal against that if it has an effect on their rights and freedoms and require human intervention. So in terms of what to do around this area, a data protection impact assessment, I suggest, would be a good way of working out, what are these, which of these individual rights are you able to comply with easily, and where do you need to kind of put in place new processes and training to deal with these sorts of requests and appeals. So, for example, any customer-facing function within your business needs to be able to know, to whom do they direct these requests as and when they come in. Nick, thank you. I think that brings us to our last slide, I think.
Thank you, Piers. Thanks for those words. And I mentioned at the beginning, Piers, that some people can ask questions. So if you could hang on and address any questions at the end of the session, that would be much appreciated. I'm now going to mute you so you can cough freely. Okay, thanks everybody. So really just picking up from where Piers dropped off, there's a lot going on, a lot that needs to be done, a lot of things to consider. One of the things to consider are what to do next. Most people we talk about are in the process of trying to find out a little bit more about GDPR and then figure out what they need to do to move forward and move their organisation forward. One of the things that you need to have a think about is within your organisation, how does the GDPR affect the various different people, and what is their role in terms of getting your organisation compliant and ensuring you work in a compliant way. We sort of split this down into several areas really. There's the owners of the company, the trustees, the board members. They're the leaders of the business, and there's an element of knowledge that these people, they may be you, they need to be aware of the GDPR, and they need to know the cost and the implication of not being compliant, and what the impact that may have on the business. And it's very important that the board or the senior leaders of the business are bought into the GDPR, as they'll be the ones that I guess will be funding it and helping you push it through your organisation. So there's an element of knowledge, elements of the GDPR that the board will need to know about. The main person within an organisation is the data protection officer or the practitioner. Not all organisations need to have a data protection officer, but somebody within the organisation will need to take responsibility to ensure that organisation is compliant. With small businesses, it could typically be the owner of the business or a director or a senior manager within the business. It could be one of you on the call today. Basically, you need to know everything about the GDPR, and you need to have a good understanding of all elements of the GDPR so you can make sure that the organisation meets its compliancy requirements. Some organisations, and some of the larger organisations, the practitioner will appoint somebody to ensure the organisation is compliant. Typically, it's somebody in IT, or could be in legal and compliance if larger organisations have those departments. Within smaller organisations, it can typically be the same person as the practitioner. But basically, this is the person who needs to implement the strategies and implement the process to ensure that you are working in a GDPR compliant manner. So if that matches yourself or matches anybody in your organisation, you need to know what needs to be done and how to do it. So you don't necessarily need to know all about it, but you do need to know what needs to be done and how to do it. And then staff really are also important and a key part of the picture. Anybody really who works in the business who's handling personal or private data needs to understand the basics of data protection, and they will have a duty of compliance to ensure that they work in a compliant manner as well. So all staff need to understand their obligations, and they need that knowledge. And one of the things ICO will look for is that the evidence and training has been rolled out throughout the organisation, so everybody understands about the GDPR and about the new data protection regime. I think one of the challenges that we're seeing out there is a tidal wave, a host pipe or whatever of information out there on the internet, and we keep a track on number of searches, and as you can see, there's some significant numbers of results of if you just type in GDPR, and we did this 6-8 months ago, and there was a fraction of these results. So what we're seeing is a huge amount of information on the internet. There's also a lot of fear, uncertainty, doubt. There's a lot of misinformation. There's a lot of good information, but one thing is for certain, there is an awful lot of information in all sorts of different formats. You can attend classroom training sessions, large web seminars and webinars such as this one. There's statutory guidance from Information Commission officers. There's the Information Commissioner's Office. There are white papers and downloadable documents. There are help from law firms and law companies to help you understand the legal considerations. There's auditors and management accountants companies who are helping, and IT companies are all helping and are all there to give you information and to help you out. There's a lot of help out there, a lot of information out there. Sometimes you could say there's too much information out there, so you can be it could be slightly bewildering. So things like understanding what's relevant, what's right, who do you trust, what are you going to have to spend, who you're going to have to get in to help you out. You've got a lot of information that you need to plow through and understand to enable you to make the right decisions to actually get going on this, because we are talking about just slightly over 6 months to go before this becomes written into the law. So we felt that it would be helpful to partner with Piers and his team at Clayden Law and build a set of resources that people could use to really understand everything that's important and relevant and correct and up to date with regards to GDPR in one place. So we've created a resource where you can go and consume content that will give the people in the organization the information they need about GDPR. And to help as well, Clayden, the team have very kindly offered to provide 30 minutes of free consultation for the practitioner or the data protection officer. For anybody who has that course, we'll provide that consultation as well to enable you to ask questions relevant to your organization and put things into a little bit of context for you. Just to give you an idea before I go in and show you some of this, how it looks. On the left you can see a set of modules and some additional materials. So we've created a set of modules and then we've grouped them together, targeted really at those 4 groups that we spoke about earlier. This is on our website, so you can go and see that at your leisure. But as you can see, the core, which is your staff, we're talking about an hour and a half of online covering the basics, definitions and individual rights, and then the practitioner who has all of the courses assigned to their particular role, which is 5 hours of e-learning. So there's a lot of content. There's videos, links to useful information, downloadable information. It's not just telling you about GDPR and what you should what things you need to be aware of. It's actually providing helpful and practical advice via Clayden Law and ourselves in that environment. So I'm just going to quickly now, hopefully smoothly, jump to my demonstration system to give you a feel for what that e-learning looks like. This is our web-based learning portal, and anybody who attends this webinar, if they get in touch with us, we will provide them access to this portal so you can have a look in a little bit more detail. But you can see the 4 courses listed here: the core, foundation, practitioner and board. If I jump into the practitioner course, I'll be able to see all the modules listed out against that particular role. Here they are. As you can see, all the modules as per the last slide that I showed you. The idea is that as an organization, if you've got a number of people in your company that need this training, we set up the system so that people get access just to the one course that they need, and then they'll go into this portal and they will take their training and it'll record the training that they've done, and then the administrator will get access to be able to pull reports out of the system, so you can see who's done training, who hasn't done training, and you can therefore chase people to do their training by sending automated emails, and you've got an auditable record of training for GDPR. I'm just going to launch one of these courses quickly to give you an idea of what they look like and highlight some of the features.
GDPR comes into force on the 25th of May 2018, and there is no end of information out there on what organisations need to do to get themselves ready for GDPR compliance. But in this 2-part module, we aim to...
So this course, we can see it's one of 17 screens long. We can flick through various different slides. Each slide has a transcript, so it's what's being said on the slide, and there's a menu where you can see that we go through and we cover data mapping. I can fast forward the slide and get to a relevant bit I like. And you can see on this particular slide there's a very helpful video that we've created to give a bit more information.
The aim of preparing a data is to get an idea of the scale of the issue, and hopefully the result will be a clearer idea on how your organisation can.
And as you may have noticed, at the end there's a little quiz, a summary and a little quiz. And the concept here is that there's some very simple questions that highlight some of the key learning that people will hopefully have got from the course itself. And if they pass that little test at the end, it'll mark that module as complete and then allow them to go on to the next module. So it gives you an audit of people's training record, together as well as the e-learning and the content within the course itself. We also provide information such as refresher guides, and these are downloadable takeaway course guides that effectively are putting the course in a PDF format. The course license lasts a year, so you get access to this for 12 months. We keep the courses up to date, and when the law changes and when new things come in, we will update the courses as and when that happens. So it's a constantly changing resource for you to access, and as I say, with an administration license as well. So I'm going to jump back now to my presentation, just to really finish off now. I think that we did a little bit of research around what's out there. E-learning clearly isn't unique. I'm sure it's not new to anybody, but it is potentially a lot more cost effective than classroom training. The practitioner course is 5 hours of e-learning. It's equivalent to 3 to 4 hours of classroom training. So you can go to a classroom and for £1,800, or you can buy the course and you'll get as much information from the e-learning course as you would in the classroom. The only thing you don't get is the ability to ask questions, which is why we've added the consultation on at the end of the course. Interestingly, we were talking and getting a bit of a feel for how much an SME spends on legal fees. So companies like Clayden Law and other organisations out there, that it's a typical SME will spend £3,000 or £4,000 on legal fees, getting a good idea of what the GDPR means to them as an organisation. And we genuinely believe that the e-learning may not save you on legal fees, but it may not eradicate legal fees, but it should offer you a significant saving on legal fees if you've done 5 hours of e-learning and learnt all about it. Then a half-an-hour consultation from Clayden Law should seriously and significantly reduce the legal fees that you may be faced with. Also, clearly, we've pulled all this together for you. One of the issues that we're finding, there's a lot of fear, uncertainty, doubt. As I mentioned at the beginning of the presentation, you can be assured that this comes with a seal of approval from a law practice. This is factually correct. The advice is good. And that's something that you can rely on. And finally, really, just keeping an auditable record of everybody's training is key to this. You need to demonstrate that you have provided training, and this system enables you to do that very easily and very simply. So that brings me to the end of my presentation. I'm just going to pause and take myself off speakerphone for 1 minute, and if anybody would like to type some questions into the questions box, I'll come back to the presentation in approximately 1 minute and read out any questions. Thank you very much for your time today, and please get in touch with us if we can be of any further assistance to you. Thank you very much. Okay, I've unmuted you, Piers. So just so as you're aware, there are some questions that are coming in, so we'll handle those questions now. Question here: what do we need to do to get access to the courses and quiz online, and also how much is the e-learning course? If you'd go to our website, www.melearning.co.uk, we do have a GDPR page, which is on the website, and all the prices of the courses are on there. I've just changed the screen with the URL. You can also contact Anna, who will be able to help you out if you want to have a look at the evaluation modules before you make any decisions, or you have any further questions to ask. Question here for you, Piers. Are you with us?
Yeah, absolutely.
So here we go. We're a B2B business. Will GDPR have the same impact for us as we rarely deal with personal information?
Well, I think the question to that depends on the amount of employees you have, because if you're a B2B business with lots of employees, that's a personal data issue, and or if not, just because if you have a marketing database of any significance, then of course that's a personal data issue as well. So if you have neither of those things, then I would hesitate to say that GDPR would be of no impact on you, but nevertheless there is a risk profile there, and I suspect you would be at the lower end of that risk profile. I hope that's helpful.
Okay, thanks, Piers. Another question coming up here is, do we have to, or what are the rules around data protection officers within small businesses? Who has to have them? I think that's the question. Or does everybody have to have one?
You only have to have one for private enterprises if you are either handling sensitive data or doing large-scale monitoring and processing of normal personal data. So when I say sensitive data, that's actually called special categories of data. That's information about someone that goes to their health or their religion, their race, that sort of thing. So those are the mandatory obligations. That said, having a DPO is nevertheless a good idea from an accountability point of view and demonstrating compliance, because it means that you have someone within the organisation who is bringing all that in together and is a point of contact.
Okay, great. One further question, Piers, and then we'll wrap it up. We buy data from mailing houses, which we then email out to companies, B2B. Who's responsible for making sure that those people have opted in?
Yeah, it's a really good question. In fact, it's something that I've just been researching very recently. So, in my view, buyers of the marketing list industry is going to have to undergo some significant changes, I think, in the way in which they compile this data. And as a buyer of that sort of data, you are encouraged to be extremely careful about how you use it, because if we're talking about individuals, whether they're at a company or whether it's a corporate email or it's a normal private email, that's personal data. And so if you're marketing to them, you either need their consent in a way which is verifiable, and if you're buying that information from a list broker, I think the ability for you as a buyer to be able to show that you have done enough due diligence on the consent picture to satisfy the GDPR is going to be very, very questionable. And indeed, I don't think many of these list companies will actually lay themselves open to that sort of level of due diligence about how they compiled the lists and how they got the consents. And they certainly won't be willing to give you the sorts of guarantees and perhaps indemnities that you could and should be looking for. So I think list purchasing is there's a big question mark over it. This is my personal view, and that said, there is scope for it potentially if you are. We didn't really touch today upon the other ground for processing, which is going to be used quite a lot by organisations, I suspect, is called the legitimate interest ground, and this is a test that you can conduct where effectively you go through a three-part test, where you look at your legitimate interest, you look at the processing. Is that processing necessary for your legitimate interest, and does your legitimate interest override the interests and the rights and freedoms of the individual concerned? And if you can satisfy that, then there's a possibility of using legitimate interest as a means for showing compliant, your legal grounds for compliance. That said, again, there's minimal guidance on this at the moment. The GDPR does allow legitimate interest to be used for direct marketing purposes. It says it may be used. It doesn't say it can and will and should be used. As I say, amongst lawyers on this particular point, there's a lot of debate, there's a lot of uncertainty about this one, and I would treat it with some suspicion. And just as an aside, we do also need to bear in mind that there is another set of rules and regulations around direct marketing using electronic communications, such as SMS and email. These are called the Privacy and Electronic Communications Regulations, which, to summarise very, very quickly, you can't use email effectively without consent. And unless you're emailing an individual who has already bought something from you or has contacted you about potentially buying something from you. It's called the soft opt-in. That is that in those scenarios you could use email. Using post is still an option, and it's possible that you could use postal marketing using your legitimate interest ground. And that obviously will be a consideration for you and for you to weigh up do the balancing test on that.
Thanks, Piers. Just somebody just commenting as you were talking, saying that is it just to be on the safe side? Is it advised that we give all of our marketing databases the chances to re-opt in? Is that really the safest?
Yeah, consent-based opt-in, positive consent-based databases is obviously the safest and most compliant way of getting your marketing database compliant. But as I say, there's a lot of organisations out there who are in a similar boat, and there is a consideration there about whether are you compliant with a smaller database or non-compliant with a bigger database. It's quality again.
Sorry, Piers, the final question before we close off the session. One question is, if the only personal data the company holds is employee data, do we still need to put in place new GDPR compliance procedures?
Easy one, yes.
There we go. Thank you, Piers. Thank you, everybody, for attending. The webinar is recorded and will be posted on YouTube, and you'll get a link to that post-event. If you'd like a copy of the slides, that's also not a problem. If you contact those via email, we'll get those over to you. I'd like to thank you all again for your time, and hope you have a great day. Thank you. Goodbye.
Thanks very much.